The views and opinions expressed do not necessarily represent those of Access Fort Wayne, the Allen County Public Library, or any other supporting group. If you or anyone you know might be interested in making a television show, please call 260-421-1250. Access Fort Wayne is a department of the Allen County Public Library.
Good evening, everyone. Thank you for coming out on this lovely fall Indiana evening. I just wanted to welcome you to, this is the second part of our Landlord Education series. We have been fortunate enough to have some great partners to put on this series to help provide hopefully some information, education, and resources to you all as you serve your tenants in our community. Just so you know, this is a partnership. My name is Jennifer Akowski-Smith, and I work as the Homelessness Strategy Manager at United Way under an initiative called Everyone Home. We're trying to address housing and homelessness issues in our community. But we are also putting these events on in conjunction with Just Neighbors, Bright Point, Indiana Legal Services, Fort Wayne Housing Authority, Metro, who is our speaker tonight, and the Volunteer Lawyer Program. Last month, we had a great turnout. I'm excited for another good turnout again tonight. In September, we reviewed, we had some local lawyers and Magistrate Douglas did a Q&A with everyone. We are recording these sessions and we'll be putting them on a website where you will eventually have access to review them. So if you missed the first session, you can go back and rewatch that. Tonight, we have a presentation from Metro to talk about fair housing guidelines. For November, we will have various organizations from the community that offer affordable housing and or resources to help individuals with rent concerns. So there will be, that one will be a short presentation and then a resource fair type presentation where you can talk to those various organizations if you have questions. And then we will finish in December talking about landlord-tenant relationships. So just kind of where we're going next. So if you registered for all four, that's great. We look forward to seeing you again. And so I will go ahead and turn it over now. We have Dennis Sorg, who is here from the city's Metro office to talk about fair housing.
Thank you. Hi, everybody. How are you tonight? Excited on the lovely October evening, our traditional rain in October, right? So most people, they hear Metro and we get frowns. I don't see too many frowns, so that's good. I'm going to try to have you not frowning quite so much. Who in here has heard of Metro? Wow, that's pretty good. Of course, landlords are probably the ones that would, right? We go to a lot of presentations where people don't know us. And one of our things that we liked about doing presentations and educational things is getting the word out there that we exist. One, for landlords, property owners, property management companies, that they get trained and understand what they need to be doing under the law, kind of what's expected of them, kind of cover them so they don't get into issues dealing with us, or you can do everything right and end up with a complaint. It's kind of the way it works. But if you do everything right, you end up with a complaint. We come in, we see you've done everything right, and we thank you, and we leave pretty quickly. So that's another reason why we like doing these. So fair housing's got a ton of stuff. So I'm going to jump in, going to kind of highlight a few of them so we can get to the meat of what you guys are probably mostly concerned with. At any point you have a question, raise your hand, throw it out at me. I'm not like wait till the end, just throw them at me. You may not like some of my answers because sometimes it's going to be, it depends because of the specificities, but we'll get into it. So,
Dennis, can I say that if anybody has a question, we're going to bring a microphone to you so that we be sure to put it on recording.
Yep. Thank you. So what I'm hoping to get through tonight is who Metro is and what we do in the city. I'll highlight that. I'll try to go fairly quickly on that. what Metro's housing jurisdiction is, because we're a city agency, so we're restricted to jurisdictional guidelines. The fair housing laws that we enforce, the prohibited acts, the it shall be unlawfuls, which there is a lot in fair housing that can be unlawful. Go over like best practices for applications and screening, tenancy rules and procedures, harassment. That's, since COVID hit, that really became a big issue in housing. People losing their jobs, the quid pro quo, because you can't pay your bill, you give me a little of this, I'll give you rent. Those have really gone up, not locally so much, just nationwide, but those have become a bigger issue. How and when to verify a disability, what reasonable modifications, reasonable accommodations are, how to engage in that interactive process to make sure you're doing things the right way. The one that we usually get a lot of scowls at, service animals, emotional support animals, therapy animals. A lot of people don't like that conversation. And then retaliation. So it's quite a bit. It's a lot of slides to get through. The early stuff I'll kind of just go quickly. Our mission is, number one, to enforce the civil rights laws, and then the empowering citizens in Fort Wayne through education. That's what we're doing here tonight. We love doing these things. Who is Metro number one? Law enforcement. We enforce both federal and local laws. So Civil Rights Act of 1968, the Fair Housing Act, Fort Wayne Ordinance G33-92. That's our local fair housing law. We also enforce employment laws, which we won't get into, and some other ordinance laws as well. Main job is to investigate a complaint. So that's where people go, oh, Metro, you're bad, you're mean, you're coming after us, right? We're a neutral fact finder, though. Number one, I want you to know that. A person makes a complaint if they meet some fairly simple criteria. I'm a member of this protected class. This bad thing happened to me within the city limits of Fort Wayne within a specific time period. That allegation is enough for us to have to be required to investigate it. We're not saying it's accurate. That's what the investigation's for. Our job's to figure out what does the evidence actually show. So we're not out to get you. We're out just to figure out what are the facts. And whatever it is, whether it supports the complaining party or supports the landlord, the housing provider, I don't get paid better one way or the other. My expectation is to show I did a good, thorough investigation regardless of what that outcome is. So I always like to throw it out there. We're not trying to prove we're not throwing out evidence because we want to get somebody. The evidence is the evidence. We're mandated to offer mediation through housing urban development. They have an expectation. They call that a positive result if we can get things resolved early on, or even at the end if people still want to mediate. It's a voluntary process. We always say it's worth giving it a shot because it's one, simpler than going through the whole investigation process, getting all the documents, sitting down for interviews. Typically, it's a couple hours of the day if we're doing it in person, talking it out to see if there's a way to resolve the issues. If it is, then we write up a settlement agreement, everybody signs, and it's done. And it can be whatever terms everybody's agreeing to. You get to play a part in how it's resolved. The complaining party gets to play a part. And if you don't like the way it's going, you just go, we're not going to do this anymore. We'll just go through the investigation. So we always say it's worth at least considering. It can be a simple way to resolve things, and you get to play a part in how it gets resolved. And then finally, education, what we're doing here today. We love getting out and doing these things, as I've said 4 times already. The areas that we do investigations in, just real quick, employment cases, that we also have federal jurisdiction in that area, housing. And then the other ordinance issues are public accommodations and education situations, which we will not talk about because we will go way over. So the fair housing laws, that ordinance I already talked about, the G3392, that's our local ordinance that mirrors the federal law. Because that mirrors the federal law, Housing Urban Development's contracted with us, and so we're essentially an arm of Housing Urban Development in the city, which gives us enforcement power under Title 8 of the Civil Rights Act or the Fair Housing Act. They provide oversight for everything we do. They're our checks and balance to make sure we're following expectations that they've set, and they set a pretty high standard. they make us work hard. So, why fair housing, right? Number one, it's just the right thing to do. We should be treating people fairly, regardless of who they are, what they look like, as long as they're following the expected rules. The other big one is it's required by law, and it can be severe consequences if you fail to follow those rules. So it can be monetary damages, that both compensatory and civil penalties. There can be equitable relief. Your loss of reputation, people are going to start seeking landlords that don't do these things. Loss of property or exclusion from being able to do fair housing. There was actually one, I want to say it was Anderson, it was in Indiana, and it was a harassment one. And this landlord's banned from had to sell his properties, banned from ever being allowed to engage in fair housing because of the harassment, sexual harassment specifically. And then personal liability. Employment, a little different, even at like harassment. My coworker's harassing me. The complaint's still against the employer. Housing, the maintenance guy is sexually harassing me. It can be against that specific individual, the leasing agent, the property manager, the corporate office. You can be held personally liable in a housing complaint, even if it's named against the property management company or whatever. So a lot of people can get pulled into the fray, so to speak. Fair Housing Act, it was signed into law after the assassination of Martin Luther King. One of the fastest laws that was ever signed in. Took about a week, looked like it was going to fail. Dr. King was assassinated, and within a week it passed. President Johnson signed it in. Initially, it didn't have all the same protections that we have today. It was basically race, national origin. Gender got added in 1974. Disability wasn't protected back then. That didn't get added until 1988. And then familial status, which is having children or being a pregnant female. And then they have senior exemptions, which we don't really enforce, so I won't get into those. They don't come up very often, at least they don't come to us very often to deal with. And basically what this is saying is it's unlawful for a direct person like a landlord or an indirect person in housing like a bank, insurance company, to discriminate in the sale, rental, financing of dwellings or other housing-related transactions. It's really pretty broad the way they interpret what that means even. We get into advertising, and advertising gets really, really broad.
Your home is not an island. Well, I mean, unless you're super rich and you've actually bought yourself an island, which sounds nice. Okay, I digress. Your home, let's say this is your home. Well, it exists within, say, a neighborhood, right? There are other homes around it. You know, a district, a hamlet, whatever you want to call it. And here's the deal. When you have that neighborhood, there might be good jobs around it within commuting distance. Or not. The schools that your kids go to, they might encourage and challenge them and give them a strong foundation for the rest of their lives. Or not. The air that you breathe in your neighborhood might be good and clean, or not. You might have healthy, affordable food at your grocery store, or not. You might be able to walk down the street without fear of crime, or not. You might be able to walk down the street without fear of police, or not. Your political representatives might be a powerful force for their constituents' interests, or not. Where you live affects everything. Your opportunities economically, your health, your safety, and your children's, and all of theirs. All depends on the place that you call home. Fair housing is at the very core of every other civil right.
And that's really, that last sentence is why we like to play this. Where you live, your sanctuary. Without that being a safe place to be, everything else really doesn't matter, right? So that's where when discrimination occurs, harassment occurs at your home, it's so much more severe than if something happens just walking down the street at work. Home's supposed to be your safe space, right? That you hear that a lot, but legitimately your home should be a safe place. And when it's not, and all these things are happening, you're affected. You don't get as good of an education if you can't choose to live in a good neighborhood. Now there's qualifications and things, right? You get to make sure people are qualified, and we'll get into that. But We like to play that so you get thinking how housing does affect people's abilities to live and live well. So I talked about protected classes earlier. So a person has to come to us, and we can't just take anything because they're unhappy. Hey, the lease is a junky lease. I don't like the lease. Well, that could be landlord-tenant law. We don't do that necessarily. It has to be, I was given a different lease than people outside of my protected class. Then that's something we could look at. Everything we do has to be tied to these protected classes. So under the federal law, that means sex, which we'll talk about a little more in a second, color, race, national origin, religion, disability, retaliation, and then familial status. So sex has kind of got interesting over the last few years. There was a case, we're 3.5 years in now, from, have you heard of Bostock? It was an employment case. Went to the Supreme Court. For a long time, there was a discussion, sexual orientation, transgender, the LGBTQ plus issues that's been occurring. Discussions, do these individuals need their own protected class? Well, this Bostock case made it in front of the Supreme Court. Supreme Court looked at it and ruled, don't need a special protected class because you can't consider LGBTQ plus without first looking at sex itself. So that was gavelled into existence under law for employment. Under President Biden and the executive staff, HUD has now enforced that for fair housing as well. So that's all federally protected right now. So we or Housing Urban Development would investigate cases based on LGBTQ plus tied to sex. Familial status, I talk ahead sometimes. That's having children under the age of 18 in the home. It covers parents, legal guardians, or expecting mothers. We've had people go, what about familial status for somebody that doesn't have any kids? Well, you usually don't get picked on if you don't have kids. It's usually people that do have kids. We don't want kids tearing up our place. That's what you hear. That's a violation. If they specify children are the problem, it's a tenant, right? Any tenant that does something bad should be addressed. We'll get into that a little more. So a little bit of background. There are some exemptions. We don't really focus on them a lot. One exemption is an owner-occupied property with less than 4 units that they're renting out. If it's single-family homes, but you don't own more than 4 homes, same thing. What that means is you can do what you want, rent how you want, rent to who you want, until you put it out into the world. It's one of those weird exemptions. If I don't want to rent to somebody that has children and I do that and I fit into that category and I'm smart enough not to make a comment, I don't want to rent to you and that's it, technically not illegal. Second, I say I don't want to rent to you because you have kids, that exemption goes away. If you LLC it, your business, even though it's so small, that exemption goes away. So we don't get into it much because it rarely ever comes up. And then it says religious organizations, private clubs, and basically that's just real quick. I'm Catholic, so I'll go with Catholic. Catholic Church has a number of houses that they'll rent out, but you have to be a member of their congregation. They could do that. As long as any protected class that's a member of that congregation has that opportunity, they can go, oh, you're Lutheran, you can't rent from us because you got to be a member of our congregation, or you're Baptist. That's an exemption. 13 years with Metro, never seen one of those, so. An aggrieved person, a little different in housing than it is in employment as well. So first, a person who claims to have been injured by a discriminatory housing practice. I didn't do anything wrong. My landlord is evicting me because I'm a member of protected class. That's kind of the easy one. The weird one with housing is a person who believes that such an injury is going to occur. So my landlord, so the first one is I got an eviction document. It happened. Second one is my landlord said, I'm sick of you, I'm going to evict you. Hasn't happened yet, haven't gotten anything official. I believe he's really going to do this. Can file a complaint on that belief. Those aren't fun to investigate because it's like it hasn't happened. It's a lot of work to figure out, but that is one that can be filed. Who can be defendants? I talked about this a little bit. So who can be potentially liable? Housing providers, municipalities, city councils, homeowners associations, condo associations, landlords, maintenance workers. And if you have maintenance workers, unfortunately, you get picked on a lot because you have so much interaction with the tenants, right? So if the work's not getting done as fast as they think it should be, a lot of times we see maintenance workers get called out. Not saying that it's been done wrong, but you have so much interaction that it does seem to happen a lot. Leasing agents, realtors, and then when we get into advertising a little later, it goes off the rails with so many more, potentially. Basically, anyone that has a hand in the business potentially could be held liable. So the prohibited acts, or what I like to call the it shall be unlawfuls. So this is the meat of the Fair Housing Act. Unlawful to refuse to rent or sell housing, impose different terms and conditions. Those are probably the two most common ones you see. Sell somebody housing's unavailable when in fact it is. We see that some. Show apartments in certain neighborhoods because you think a person belongs there because of their protected class. So all these have to be tied to a protected class. The telling somebody it's not available when it really is, you'll see testing a lot. A person says, hey, I called them on the phone 15 minutes before I went over there. They said, yeah, it's available. They saw who I was, and all of a sudden it's rented. Suspicious. So I had a friend go in that's different than me, and it's a test. Hey, is this available? Oh, yeah, here's the keys. You want to go look at it? I hate to say slam dunk, but that's one that's going to be a violation. Agencies will do testing. We typically won't. We may on specific cases, but Housing Urban Development does. The Indiana Civil Rights Commission, who is the state agency like us, has an active testing program. There are FIPs, which we're a FAP. I won't get into that. FIP is more of an advocacy agency. We have one in Indiana that I know of. They will do testing, but individuals can do testing. So another reason to make sure you're being consistent in what you do. More unlawfuls. Already talked about retaliate, but that's an act of harm because someone has asserted their fair housing rights or been a witness in a fair housing complaint. So asserted that they felt discriminated against. It doesn't have to be a formal complaint with Metro. It could be. I went to the leasing office and I said, hey, I think the maintenance guy is treating me differently because. Doesn't have to be all formal. The Civil Rights Act of 1968 says you're not going to get that. I feel I'm being treated differently because. That's putting you on notice that they're engaging in their civil rights. And then because they did that, people get mad. Oh, you think I'm discriminating against you? I'll show you. And then they take some new harm, even though they've done nothing wrong. That's a retaliation complaint. It's unlawful to make assumptions about somebody's ability to pay based on, this says disability, but any protected class. Deny property insurance. If you're not insurance companies, you're probably okay, but we hear our insurance company won't insure us if we have this animal in as an emotional support animal. We'll ask for your insurance company's name and they'll probably get a Metro complaint. Because if it is documented that this person needs the animal, probably going to be a violation. Not that you've done anything wrong, but your insurance company may have. To make, print, publish a notice, statement, or advertisement that indicates any preference, limitation, or outright discrimination based on a protected class. So this advertising isn't just in writing, isn't just commercials, isn't just what's on social media. It's word of mouth, counts as advertising. And unfortunately, a lot of housing providers are smaller housing providers. They're not big companies. You have a handful of houses maybe, and you like, it's my house, I can do what I want. I don't want to rent to, throw in a protected class. They'll just come out and scream it. Probably you might not want to be in fair housing then, or in housing. because you're going to get in trouble. I see a hand up.
So can someone publish and say one-bedroom apartment, et cetera, no children allowed?
Would not be smart. Again, familial status is a protected class. We ran into one, it was a big one actually, and it's in court now and everything. There's this old rule, 2 heartbeats per bedroom. Are you familiar with that? For the most part, throw that out. HUD says it's about square footage is more important. This company, we kept saying it's about square footage. This is a huge house. It was a big family, really, really big family. But it was a really, really big house. And they kept going, nope, it's 4 bedrooms, 2 heartbeats per bedroom. They got too many people. No, here's what HUD's guidance says. Don't do this. We're trying to get you not to get in trouble. We're telling you before we get into this. Nope, nope, nope. We had to go in. We did all the square footage calculations. Didn't even count the basement because it didn't have exits, the windows are. So we didn't even count that, which somebody wants to live in a basement, they probably can, but we didn't count it because it's not legal, right? They violated the law because they stuck to the 2 heartbeat. If a person wants to have one of their bedrooms be the living room, they can. Again, it's a square footage thing, and I can't tell you the exact numbers. HUD's website's got tons of information. If you have questions, that's a great place to go to look things up. But yeah, saying no children in general, bad idea. We see a lot of in leases, children should not play in the parking lot. Real easy to fix. Should anybody be just hanging out, screwing around in the parking lot? No. Tenants should not loiter in the parking lot, or tenants and their guests. You've covered it without picking on kids. More unlawfuls. I'm covering slides without even getting to them. Look at this. To enforce a neutral rule or policy that has a disproportionately adverse effect on a protected class, that tends to be a felony conviction issue. HUD's got another great guideline saying you should weight it. How severe was it? How old was it? And it should meet in the middle. Blanket no felony laws tend to be problems for, as a potential violation. I will say, sex offenders, HUD will tell you no protection. Doesn't matter how old it is. If they have a sex offense, conviction is the other important thing. We've ran into a lot that you'll use my case, and they'll see, oh, it was an arrest. They don't bother to check down at the bottom or see what the outcome was. If it's an arrest, they're not really guilty of anything. You need to make sure it's a conviction. Refusal to permit reasonable modifications to an existing premises if it's needed. Reasonable modifications generally is the tenant needs to do. It's going to be on them unless you get federal funding, and then it gets different. But if you don't accept federal funds for your housing, generally the tenant's responsible for modifications. Making reasonable accommodations is mostly for the rules. Hey, my disability makes it hard for me to leave the house and come to pay. Can you send somebody to pick up the check once a month? Or I get my disability paycheck on the 5th of the month. Can the 5th of the month be the 1st of the month? HUD says all those things are reasonable, and there's a bunch more that it could be. And then there could be some that's unreasonable. Because of my disability, I can't drive anymore, and hey, landlord, you need to drive me to go grocery shopping. People will do that. You see, you just said you have one. You don't have to do that. That fundamentally alters your business. You are not a taxi service. So, I need to do everything for it. Right. So yeah, that would be one that we would say, no, yeah, the landlord's not on the hook for that. And then fail to design and construct covered multifamily dwellings. If it's built, and I want to say April 1993, there's different standards. The doorways didn't have to be as wide. The slopes of the drive or whatever, that access, they were different. So there's new standards after, and again, I think it's April of 1993. We don't get many of those because most places know when they build a new building, they got to meet those wider doors and stuff. But another reason to be making sure if you're building, your contractors are doing things the right way. Application and screening process. You all want to be able to make sure that you're getting good applicants, right? Somebody that's going to pay the rent, that you aren't worried they're going to be a problem tenant. You have every right to do that. It's really about consistency. So, like I just said, you have every right to determine if they're going to be a good applicant. Do they have the income? Do they have a rental history that says, and I say says because they can look perfect on paper until you get them, right? But do you have that initial information? Go, yes, I feel like they should be a good tenant. You have every right to get that kind of information. Big thing is process that application consistently, no matter who it is. The neutral policy one, we see issues sometimes with convictions. Big burly guy, I'll act like I'm really big and burly, come in with a particular crime that I was convicted of. Or a female, potentially, much smaller, 100 pounds, looks really sweet, committed the exact same crime as I did, armed robbery, whatever. Oh, she doesn't look dangerous. Look how nice and sweet she looks. Denny, big scruffy guy, looks scary and dangerous. We'll rent to her, but not rent to you. If you have the policy, enforce the policy regardless of who the person is. I know I don't look big, burly, and scary, but...
When it comes to immigrants,
No.
so is it okay to ask for U.S. issued ID only?
Good question. No. Their immigration status does not matter in fair housing. They don't have to be here documented. It's actually will come up. Basically, what the rule is for identification is it enough that you can verify the person is who they say they are? There's nothing that says you have to have a state-issued ID. It could be a green card. For us, like, we have to notarize. It's basically if it's their picture and it has the name that they say they are on it, for notary, we accept it. We do not require specific forms of identification. And it says be careful, like, if you're going to request that specific identification from one group, you better ask for all this extra documentation from everybody. I need your social security card. I need your graduation diploma, right? Whatever it is, whatever you establish, you better do it for everybody. Because if you pick and choose what you're asking for based on a protected class, gonna lead you down a path of potential violation.
Okay, so in my scenario, they own their home and only rent their site. They have to be able to title that home through the BMV, and those are the BMV's requirements. I'm kind of stuck there. What do I do?
BMV, that's a good question that I would say I would talk to an attorney. I think I saw Perry's Law Office here. Because sometimes there's laws that are conflicting. Service animals, emotional support animals, somebody says, I want a cow for my emotional support animal, and somebody goes, you're in the city limits, you're not allowed to have a farm animal in the city limits. It's under ordinance whatever. Conflicting. So then you might have to go talk to city council and see what they think about that and make an amendment for you or whatever. So I don't have a great, go ahead.
No, I'm sorry.
I was just going to say, I don't have a great answer, and a lot of these you probably aren't going to get the solid answer you want because a lot of scenarios, it depends. Like the state's involved. The state trumps metro in most cases. We're going to go, well, it might be an issue with whatever the state requirements are. But most of the time, I don't know how what the requirements are for getting a state-issued ID even. That might be a lot easier. I mean, it's always been easy for me, but I grew up here. So I don't know if that's just easy because I started off here and I'm not trying to jump in the middle. So I don't have a good answer.
But it's okay to say across the board, we require a state ID, as long as it's across the board.
You better be consistent.
Right.
But also limiting, like, there is a specific slide, and we have not ran into this, so you're making me think and work hard. Because it also talks about asking for a specific identification could be a problem. We'll hold that, and when we get there, throw your hand back up, because I'm hoping something will click in my brain a little more.
Series and this one, there were several issues that were brought up that we did not have an answer for, and at the fourth session, we will address any from all 3 sessions that did not get addressed at that time. So if we can't get an answer for you tonight, we'll have it by the 4th session.
Because sometimes, plug for Indiana Legal Services also, if we don't have an answer, we will suggest call Indiana Legal Services. They may have because they do a lot of pro bono, right? They might be able to get you some answers on the legal side, because a lot of times we can't tell you because we are an investigation. We can't say, do this. I can't give you, this is my legal advice. These are best practices. Because if I give you the legal advice and then you go, why are you investigating me, Metro? You just told me what to do. No. So we talk about best practices. So when it gets in those nitty gritty areas, we're like, talk to an attorney. That's our out. So again, you need to apply your rules equally. We say screen on a first come, first served basis using that objective criteria. So we always say date, time that the application was received. Because if you get 2 people come in at the same day, approve the first one that came in and if they were approved. If they weren't approved, go to the next one. That way, when somebody says, well, I came in on this day and so did they, why wasn't I approved? Well, you were the second one and they came in first, they got approved, so they get it first. That's a legitimate, non-discriminatory reason for doing what you do. Use pre-printed documents to ensure consistency. That's always important. That way somebody can't say, I was given different information than somebody else. If you're doing a rental special, have it printed out. Don't just, on a notepad, give it to somebody and somebody else is getting something a little different. Being consistent is very important. And we've noticed a lot of landlords, at least larger ones, are now using the digital recording systems. So payment ledgers are online, maintenance requests are online. So it's automatically being tracked and documented when it was received, when the parts were ordered, when it was completed. That consistency is big in a complaint. Show even documenting communications when maintenance has been delayed. That's huge, because people are going, man, they're just blowing me off. It's usually we see a lot of times it's just people aren't talking to each other. There's a legitimate reason. COVID hit and you couldn't get anything shipped. Took forever. People still want the roof to not be leaking, right? Well, I can't get the stuff I need to fix it. Have that conversation, keep them updated. That avoids a lot of people creating a story of why things are happening to them. Won't fix it all, but that communication is a huge way to avoid issues. Photo IDs, we're there. Let's see if this helps. You can require it for safety reasons or verification of identity. Require from all applicants, so just because somebody looks like they're from a different country, I'm not gonna ask for something that I wouldn't ask for somebody that looks like they're from Fort Wayne, Indiana. Use caution when requiring limited or specific forms of ID. That's about as specific as HUD has us get.
So I get a lot of legals that have gone through the process.
Right.
They have TIN numbers.
Okay.
They have TIN numbers
Okay.
instead of SS, but I don't always ask everybody for a TIN number.
It's really, because, that's going to be a difference for somebody, right? It's really, you're not going overboard, right? If you're asking for a Social Security for a person and, well, you don't have one, so you're giving me your TIN, right? Kind of equivalent. I get your question or your concern. Hey, they're different. Is it okay? But you're not going overboard going, I need this, and this because of who you are. Hey, you don't have this, so you're giving me this? Cool. That would be okay. C, again, I already said date and time stamp those applications. You can ask for identity documents and like things from credit cards, bills, bill documents showing, does this have your name on it? Does this have an address you say you lived at? If you can ask for those types of things. Sometimes you want to just make sure they have a good credit. Well, you need to do a credit check, right? You need to be able to verify your checking credit on the person you're running the credit check on. And again, their immigration status does not affect their federal fair housing rights. So I shouldn't stand on one foot. Their immigration status may keep them from being able to be employed under the law, right? So you're supposed to be documented, and but if they've got a job, whether they're here documented or undocumented, under fair housing, it does not matter. Everybody has the right to have a place to live. I know it makes it tough when you think, but you're not allowed to employ somebody. Well, that's not your problem. You're not the employer. Can they pay you to live there? I love this one because it will make you chuckle a little bit, but it also gets a really good point across.
Hello. Yes. Can I ask a few questions about the apartment on Park Street?
What was your name?
My name is Juan Hernandez.
It's been rented.
Oh, he's gone. Hello, my name is Sanjay Kumar. I am calling about the apartment on Park Street.
It's not available.
Not available? Hello, my name is Tyrone Washington. I'm calling about the apartment on Park Street.
Just been rented.
Hello, I am Chen Ling. My name is Khalid bin Ali. I'm Tuan Vo. Hello, my name is Moshe Goldberg. I use a wheelchair. It's gone. Not available. All right. Thank you. Yes, hello, my name is Graham Wellington. I'm calling about the apartment for rent on Park Street. Is that still available?
Yes, it is.
What is?
Yes.
Really?
Housing discrimination is illegal. If you think you've been a victim because of your race, color, national origin, sex, religion, disability, or family status, call us. Fair housing. It's not an option. It's the law.
So this is a guy that's doing testing, actually. Has the classified ad, says, ooh, we're going to test this property. And so he calls and he starts doing all the stereotypical accents. He does like a Middle Eastern accent. He does a Southern accent. Sounds like he's the stereotypical Southern African-American person. He sounds like he's a Chinese. Goes through all these different accents. And it's, no, it's not available. No, it's not available. No, it's not available. No, it's not available. And then all of a sudden he does this real prim and proper, like, English nobleman with the monocle. Yes, this is Bruce Wellington of blah, blah, blah. I'm inquiring on this rental. Oh, it's available? People will use accents to weed out who they think somebody is. That would be a violation. That's an example of testing. Being denied based on somebody's English proficiency or having an accent is unlawful. So it doesn't say that you have to have all your stuff translated into different languages or that you have to provide translators. Unless you get federal funding, you may be required to. But you need to show that you're trying to help the person get through the process. You have to show you're making the effort. The big no-no is you're too hard to work with, go somewhere else. That will get you in trouble. But showing that you're trying to help the person get that application in, that's what's important. Making those reasonable efforts. So no blanket refusals of English proficiency. You can't speak the language of your choice on the property. That's illegal. It's even problems at work. Oh, yeah, I keep forgetting on the microphone.
So, and I get this occasionally, someone that just dropped into Indiana, and you don't understand them, and I keep asking on the phone, can you repeat that?
Right.
And they eventually hang up on you.
You haven't said, go away, I don't want to talk to you. You're trying. It may be, hey, do you have somebody that can help me understand? The big thing is, like, if they give up first, it's kind of with disability, there's an interactive process also. Basically, what I say is you don't want to be the first person to give up. Unless you get to a point there's just nothing more you can do, that kind of gets into reasonable accommodations for disabilities. You don't want to go, no, I don't want to deal with that, and walk away and end it. Well, maybe I can't do this accommodation, but we can maybe do this one that's going to work for you. You're engaging in that interactive process. That's kind of similar here. I'm trying to get you through this. Do you have any way that's going to help me? Some properties, though, like we have a large Burmese population in Fort Wayne now, right? Some properties have a lot of Burmese tenants. And so we've got so many Burmese tenants, we are going to translate stuff because we have so many tenants that speak the language. So based on the population you serve, it may be worth considering. Like Metro, we generally have our stuff in English, Spanish, Burmese. Those are the big three in Fort Wayne, right? And we have a bunch of others, but until they get to a point where we can show that it's enough of that language to print those, we will then. But we want to get that information out. That's the key thing. The law doesn't say you have to translate, but if you're big enough and you deal with a big enough population, it's worth considering. So HUD guidance on, did I cover everything? Yes. HUD guidance on background checks. The last one was issued April 4th of 2016. We've actually got one that we're kind of looking into deep. We're actually having a bunch of research done because this could be getting into the nerdy stuff, disparate impact issue, which that means it's impacting more than, or potentially impacting more than just the person that filed the complaint. So it prohibits discrimination practices that have an unjustified discriminatory effect on a protected class. Typically, it's that no felony rule, because if you look at crime statistics, certain protected classes tend to have more police engagement. People with disabilities, people of different countries, people of certain ethnicities, right, tend to have the police interacting with them more often, and so they tend to be arrested more often. Again, an arrest does not mean a conviction, so number one, you need to look at actual convictions. Two, that blanket, if you've ever had a felony, I don't care if it was 50 years ago, you can't rent here, HUD says is a big no-no. Now, if they just got out of jail from an armed robbery, it's only been a year, is that legitimate to still deny them? Potentially. I'd say check HUD's website. It'll have a cool little graph to walk you through it. Or is it somebody that got busted with too much marijuana in 1973 and it was a felony and they've never been in trouble since? Are they really probably a threat to rent to? No. That's why HUD says you need to balance this out. And again, whatever that policy is, hold everybody accountable, even if you think that person looks really cute and safe, opposed to the guy that looks big, burly, and scary, like me. Although I'm guessing I don't look scary. Again, gonna harp on it, distinguish between arrests and convictions. It's all about the convictions. I say it a lot because that's what we see. The landlord says, I didn't do anything wrong, here's my case. And right up front, it just says it was an arrest. If you scroll all the way down to the bottom, it was dismissed. No, it needs to be a finding. Also, no blanket bans or prohibitions. So this is one, like if you go, hey, we have a concern, HUD suggests they should have a right to appeal that. Maybe they did have a drug issue, but they've gone through counseling. They show they've taken these steps to be a good tenant, to have kind of that interactive process. Again, like I said, sex offenders, we used to have a person from HUD do this training, and they go, you can tell them to live under a bridge. That was her statement, I believe. You have no duty to house them. Sorry.
With what you just said, that's not consistency.
What with?
With what you just said. It should be on a circumstances case by case.
Are you talking about the sex offender?
No. For,
I was going to say the same thing.
Oh.
This slide says no blanket bans, and the previous one said you can do it, but you got to do it across the board.
Well, and that's again where you have to balance. I understand what you're saying. like the blanket, no blanket bans would be for anything but like sex offenders. You don't have to ever house. But blanket drug possession. So if it was, and I think it may be in the next slide. Oh, no, it's down at the bottom. So convictions of manufacturing or distribution of controlled substances, same thing as sex offenders. They've been making drugs to make money, opposed to I got busted because I had a bag of weed or whatever substance. So there's some distinguishing things, and that's where it gets technical under what the conviction is. Big thing is look for convictions, not arrests. Once it's a conviction, then you want to go through how severe was it? Was it murder? Was it battery? Was it last week? Was it 20 years ago? What did it look like in between those times? You know, what did their criminal history look like? And it's all about trying to judge, does this look like it'd be a good, safe individual to be my tenant? Would I want them around my other tenants?
So can I, as a landlord, say no felony convictions in the past 10 years? Can I do that blanket statement?
We see it a lot. Again, it can get messy because what we see is landlords make exceptions is where it gets messy. Consistency is the number one rule, we would say. HUD has sometimes the opinions kind of, depending on what part of HUD's guidance you're reading, they don't always quite mesh as well as you hope they do. But consistency, number one, hey, this is the guidance. I apply, if it's this felony, it applies to everybody. That's generally, that will keep you safe, because what won't keep you safe is I applied the rule to Denny, but I didn't apply it to Samantha.
Yeah, I have a question about that.
You guys are making me work hard.
Sorry. About the drug charges. So if somebody's on a problem-solving court, like drug court or something, they've pled guilty to their charges. They show pending, and it could show pending for 2 years or however long it takes them to finish drug court before it's dismissed. Is that a fair housing issue?
That's a question. HUD says it's a conviction, not if it's pending, it's pending. It's still not guilty of anything. We get asked that.
Like,
what do
oh
I
my
do
gosh.
then? It's frustrating, right? Hey, we're going to let you move in, but if this turns into a conviction, it's going to also turn into an eviction. Hey, that rhymed. I know it's tough because you're like, why do I want to go through the effort of allowing somebody to move in just to have to go through the eviction? It's a battle that you would have to decide you want to take, I guess. It's a weird situation. That's where I would also go talk to your attorney because I'm just talking best practices, kind of the way our minds work from what HUD says. But there could be valid reasons for the pending. But we've had one that went probable cause because they said, hey, once you get that figured out in court, come back. What do you mean figured out? She's not guilty of anything yet. Yeah, but it's pending. What if she is? What if she's not and you denied her housing? That's the other side of it. I gave it away. It was a woman that time. Sorry. No names, so I didn't break any rules. Here's one that's just real quick, a court case where a person alleged at this apartment complex discriminated against them based on their race when they were denied a rental application even. And they said they were denied because of their race and because he disclosed he had a criminal record. But at the same time, this is what we generally see. They approved 2 white tenants with the exact same conviction. That's typically what we see when it's an issue. It's not so much that the policy was so strict that it's affecting somebody. We generally see people aren't applying it equally. That's generally the bigger issue. So, tenancy rules. Again, same thing. Don't single out based on their protected class. Make sure all your rules, policies are in writing. Generally, I think most leases have the expectations listed out in them, right? Sometimes there's additionals, there's addendums and things. Whatever the rule is, just like the conviction or the criminal history one. Enforce them the same no matter who it is. Keep written records of all actions that you've taken when enforcing resident rules and policies, even if it's not an official lease violation. Maybe it's just a conversation. Like if it's an appointment, we call it a verbal warning. Document the verbal warning. I had a conversation with Steve today because I got notice of this. Warn them if this happened again, it would turn into lease violation number 1. Even if it's just a conversation, document it, because you documenting it is building a trail of why you end up doing what you need to do. That's where a lot of problems are. People aren't consistent in their documentation, and that's what we look at. How consistent are you handling this? The more consistent you are, the better documenting you are, the easier it is for you to show you're doing things the right way. And maintain those records. We typically go back a year. Depending on what the issue is, we may request 2 years of documentation. Generally, say it's a tenant that's been there 15 years, keep their stuff until they leave, right? Can make exceptions in the rules, but never do it based on protected class. Like this one's late fees. I had a tenant that's been here 15 years, never paid late. It's been the best tenant I ever had. COVID hit, job shut down. They couldn't make their rent on time. I didn't charge them late rent or the late fee because they've been such a good tenant. I waived it that time. They're back on track, no more issues. You document that you made that exception to the rule. Because what you're going to get is the brand new tenant that lives right next door to them. They're going to talk. You didn't get charged a late fee? I got charged a late fee. They also didn't disclose that they've been there 6 months and paid late 3 months in a row, right? So you document why you made that exception. So exceptions can happen. Rental move-in specials. You document why they're getting the first year $50 cheaper a month because you ran a special. Keep those records. Without the records, then it just seems like you're kind of doing things willy-nilly. Yeah, oh, sorry, I keep forgetting about the mic. I'm loud enough that I usually don't need a mic's the problem.
So, a lot of my understanding is on the specials.
Mm-hmm.
Say you got a special for veterans.
Okay.
For like $100 off a month or whatever. Do we need to cover all categories?
No. So if you're doing a veteran spot, because veteran's not a protected class under the Fair Housing Law. So as long as you're allowing any veteran, no matter what protected class they're a member of, black, white, male, female, Hispanic, as long as you're allowing them that qualify to rent to have that special, all you need to have is a piece of the paperwork going veteran special. But then there's like,
Let's go with the protected class, like LGBTQ.
no, that's illegal.
So,
You have to have that special for anybody.
okay, that's what I'm asking.
So that would be the month of August move-in special. But for the month of August, anybody that moves in gets that special. But yeah, once you say, because I mean, LGBTQ sounds like, oh, why couldn't I? Put it in reverse and go, white people get a special this month. Whoo, right? Then all of a sudden it's like, okay, I get why you didn't do that.
Okay, going back to the criminal record for a minute.
Yeah.
A few years ago, I had a couple ladies come to my house, young ladies, wanting to rent a house. I can't remember the specifics, but I think it had something to do with one of them had a recent shoplifting on a record, and I believe it was a felony. I didn't want to deal with it, and I didn't want to deal with them. So what I thought for a minute, I went back to my office, I'm like, what am I going to do? And I came back out and I said, listen, I could rent this house to you, but I'm going to ask for a lot more money up front from you than what I've been asking. So I think I asked them for like first, second, last security because I knew they weren't going to be able to afford that anyway. So how did I handle that? Was that within my rights to do that?
That was smart. I don't know if it was good. That I would usually say you have an attorney on the phone quick to go, hey, here's my issue. What should I do? Because I haven't heard a protected class outside of it was a female.
They were protected.
Right.
They actually were.
Well, I mean, female's protected, race is protected. But changing. I mean, like if you had a credit history and they had bad credit, hey, it shows that you may not be paying rent as consistently as others. So that's where you would see, I need the first, second, and third month up front before I'm going to rent to you because your credit's sketchy. The criminal history for that, I've never heard of that one. I do not want to tell you that was the right thing to do, but I probably wouldn't have. But I'm also not an attorney. I'm just an investigator, which is why when I'm not sure, I'm like, call the attorneys. Yep.
From previous films, back. So like, say I come in, I have like 5 applications, all came in, that night before. I can't go with most qualified. Out of those 5, it'd have to be that first one at 8 o'clock in the morning.
So the first one that is qualified. So if that 8 o'clock one is qualified, it doesn't matter who's most qualified at that point. If they met the minimum qualifications to rent, it's the first one. Like employment, it's, oh, yeah, they were qualified, and that's why we interviewed them. But we didn't hire them because they were the most qualified. You can do that in employment. Housing, it's the first one that meets the qualifications. It's not the most qualified.
I have a question relating to that first in, first serve kind of application stuff. If a lot of times when applications are turned in, say there's 5 turned in on one day, some applications take longer to process than others. Is it fair to allow it based on first that's able to be approved? Because some things are out of your control as far as turnaround time.
I mean, the training, that's a very good question. The training that we've always given is the first one that applies that qualifies. I totally understand your question, and that could be a very good argument. I can't say that would be wrong. Hey, yes, they all came in and we submit them and all, but this one came back as clear first. That could be legit. You're going to hear me say could be legitimate. I'm not 100% sure, but it's a non-discriminatory reason. I can tell you that. Under an LNR, that does not sound like you're basing it on protected class. We send them out. We have a third party that qualifies them. This one got done first. We had nothing to do with it. And oh yeah, by the way, the third party doesn't know what their whatever protected class is. So in my head, I'm working it through. It doesn't sound big and scary to me like some of the other ones. Ooh, you guys are working me.
What about a blind comparison? If all the applicants are looked at with just their criteria, and someone who hasn't been involved in the process just looks at all the criteria and decides that way?
Right, when that's like that third party. A lot of places use third parties because they're like, we don't collect it, we don't tell them, they don't know who the person is, they just see the numbers, right? That is another legitimate, non-discriminatory reason. You hear that when I say LNR, the business is saying this is what we did, this is why it's not discrimination. The people that made the decision has no idea what their protected class is. They're looking at the numbers. Do they make enough? What's their credit history? They wouldn't know their race, their sex. They may know their sex if they get the dame, but if it's just based off a social security number or whatever they're using to gather that information, yeah, if it's blind like that and they can show we had no idea what this person's protected class is, probably going to be okay. I say probably because you hear that depends a lot from us because each particular case has its own little intricacies that can just change everything also, which is why a lot of times you also hear me go talk to your attorney on some of these because we hear what we hear, but then one little thing's different, it can change the whole issue in the end. So that's why I cop out with the it depends or talk to your attorney a lot. Outline the expectations of behaviors in your rules. We expect timely payments. Payments are due on the 1st. If they're not in by the 5th, here's the late fee, right? Quiet hours, designated parking. Don't tie it to any protected classes. It's great to have an anti-harassment, anti-discrimination policy included in there so your tenant knows if they feel they're having an issue, what they should do. Oh, you feel like this has happened, you want to come and report it to the office. We'll take your information, we'll investigate it, we'll do it timely and thoroughly, and we'll address the issues as we need to. Now you're going to run into people that go, what'd you do? Did you fire the maintenance guy? The law doesn't say you have to fire anybody. You have to make it stop if somebody says, I was harassed. If it really did happen, you definitely need to make sure it stopped, whether that's a write-up, a coaching, a suspension, if it's bad enough, termination maybe. But the law says make it stop when it's harassment. The cover yourself for like a harassment issue, somebody complains, even if you don't substantiate it in your investigation, you still put the alleged harasser on notice. Hey, I'm letting you know we looked into this. Nothing shows that you did anything wrong. However, if this would occur in the future, that would be a terminable offense, for example. You've still addressed it. They're on notice, and they're not in trouble. The tenant just, all they're allowed to know is it's been addressed. You shouldn't have any more issues. If another issue comes up, let me know so we can handle it. You see that a lot in employment, too. Well, the guy's still working here. Yeah, the law just says they have to make it stop. It's kind of the same thing for a landlord. You're going to ask about a neighbor that's not your tenant, aren't you?
No.
Okay, good.
So if I got tenant on tenant doing this, how do you proceed?
Carefully. I mean, oh, I'm sorry. He said, what if I have two tenants, so like neighboring tenants, I'm assuming, and they don't get along, right? That's what it sounds like. Right. So, good thorough investigation. We actually have this as an employment one that I can kind of twist in this scenario, where guys at work like to tell, sexual jokes, talk about their sexual prowess, I think is how it goes. Deborah is offended by it, but she'll talk about sexual things with another coworker. And so everybody knows this is going on. Deborah complains to the boss, i.e. landlord, hey, this is happening. I don't like it. Make it stop. Okay, I'm going to look into it. You address the person, hey, I hear this is going on. If it is, knock it off. And if you have evidence, maybe it could be a lease violation. Most likely you're going to hear that person go, because it's neighbor on neighbor, right? Well, they're doing this same stuff too. You know what? Just like in an employment situation, if I was the supervisor and those guys say, yeah, we did it, we'll stop, but Deborah's doing it too, I better go back over to Deborah and go, hey, found out that you're having these conversations, you're doing these things, that's inappropriate as well. It needs to stop. So sometimes you might have to ding them both. Sometimes it might be worth, hey, can we sit down together and figure this out? The big thing is trying to get them to get along. Depending on the size of the property, maybe one of them moves to a different unit. If that's an option, it may not be an option. Might mean you have to just keep a closer eye on that unit, pay attention. Maybe one person is the aggressor and the other one's just, as landlords, you guys are taking on a lot. You don't just have Metro and fair housing. You have landlord-tenant laws, you have neighborhood code, you guys, a lot of things that you're responsible for that you have to make sure is right. So you guys, I give you guys a lot of credit. I couldn't do it.
So like if he was an employee, you would fire him?
Not necessarily.
If it came to that point?
Potentially.
So would it?
You could evict a tenant. Oh, yeah. If you go, look, whatever your, like, some places, three strike rule, you're out. 3 lease violations, you're out. If it goes, look, I've been here a month ago for this. We talked. We found out you did it. Maybe somebody has a recording, shows that they did it. We had one where somebody had a gun pulled out on them just trying to move their stuff out of an apartment. And they didn't leave. I'm like, the second I saw the gun, I'm like, my stuff can stay. I'm like, but the person that had the gun was mad that they got evicted. They did not realize that there was a video of the incident, right? They evicted me because of my race, I think was the thing. No, they were pointing the gun and arguing. And I'm like, I'm watching the video, I'm wanting to duck. That's probably a 1 rule violation. You've got evidence like that, oh yeah, you're the aggressor, that's a problem. That's not just an argument at that point, that's a safety issue.
Could I?
Yeah.
We have about 15 minutes left, and before, at the end, when everybody gets up, we do have evaluations again, and your fair housing certificates are on the wall by last names. But the one question that we got the most from the landlords when they signed up was about pets. So I wanted to
That
make
was the
sure
one I was
that
just-
we got to that before
I wanted to
ran
make
out
sure
of time.
we got there
Okay.
too.
Thank you.
Because that's usually pets, emotional support animals, that's a big thing. So I'm just gonna, when it comes to rules, policies, issuing violations, document, 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 be consistent, consistent, consistent. That's your best friend, right? So then, again, a little bit here real quick though. Family-friendly rules and regulations. Again, don't put in your lease, children shouldn't be playing in the parking lot, no loitering in the parking lot. Children can't be outside loud after 10 p.m. Quiet hours begin at 10 p.m. for all residents. You're getting the same thing accomplished. It shouldn't matter whether it's a kid being loud or an adult being loud, right? If you have a pool, you can't have adult-only hours. You know, adult-only swim times for 15 minutes on the hour. It could be lap times, lap swim for 15 minutes on the top of every hour, but as long as they, you know, everybody's willing just to swim laps, everybody should be allowed to. So that's usually the biggest thing we see is a lot of rules like to say children. Tenants, guest, and what's the other big term tied to tenant? Occupants, I think. Tenants, occupants, guests need to obey these rules. Doesn't matter what their age is, what they look like, who they are, they need to follow your rules. Now you're not specifying a protected class, you are fine. So then, harassments, well, see how much this is? I'm like, we could go to 10 o'clock. I know you don't want me here this long. So kind of getting into the animal stuff first. When it comes to like emotional support animals, service animals and all that, first it's disabilities, the first thing to realize. So because people will give you, right, you'll see this, my dog is certified as an emotional support animal. Worthless piece of paper for you having to approve the animal. They got ripped off by $100 probably on some online thing. It's not about the animal. It's about the person. So is it a person with a physical and mental impairment that substantially limits one or more major life activities? And then that's the big one for the animal thing probably. The other things that we look at when somebody alleges a disability issue is, are they regarded as having an impairment or do they have a record of an impairment? So I just wanted to cover those real quick. The first one's the one that would come into play mostly for emotional support service animals and things. So, because people get really worked up about, see, look at how many these are before we even get to it. So, fingers crossed this plays. This is the reason why the law exists, this scenario. Because just real quick, what it's going to show is this little boy is autistic. They have other dogs, but even with these other dogs, he won't touch food. He's basically nonverbal, shut down. They rescue this pit bull, and I emphasize that because everybody goes, oh, it's a pit bull. Well, a little chihuahua could tear your butt up too, potentially, right? So, pit bull that was abused, right? They have this connection that is amazing. It played earlier. Oh, man. Usually if we play this, you don't even have questions. That's why I was so hoping it was going to play. Really? All right. Bummer. So, you don't get to see this, but really what it was, like I said, kid wouldn't touch food, was nonverbal. In this video, He's talking up a storm. He's cutting up fresh food for the dog, for all the dogs. This dog is by his side, brought him out of his shell, made it so he was living life. And that's why you could have a pet. That pet does not do you any good. It's an emotional support animal is like a medical device. It's like helping me like a wheelchair would help me. So they're not pets. And so by that, you can't charge charge them pet fees because you can't charge somebody on crutches or a wheelchair extra, right? You're viewing it the same way. I have somebody with a question. I have a question up here. Sorry, I know you're trying to do multiple things. I'll let you ask your question.
So I don't know how many people actually want this question answered.
Usually nobody.
Because this is such a touchy line on
it. It is.
Especially so we know service dogs go to a 2-year camp most of the time.
Most of the time.
Not all the time.
Right.
And an ESA is not really a trained dog for...
No. It is no different than a pet other than it helps that person.
Right. And I know not to charge them any money or anything like that.
It's okay, just throw it out.
How do you not discriminate? How do you tell if a person needs an ESA?
Fair question.
Without HUD says you can't ask any fucking questions.
No, you can ask some questions. It's okay to get some verification. Because if I want to keep my pet, and it's always just been a pet, and you go, I have a no pet policy, oh, now it's an ESA. Just because I said it's an ESA does not make that true. So if somebody says, well, this animal is my ESA, do you have some documentation that shows you have a medical need for this? So they need to show you in some fashion, I need it because of my disability. So that's where this is the answer that starts to get people a little touchy. A doctor, real easy. On doctor's letterhead, this is my patient. They have a disability. This animal assists in that disability. Those are awesome, great. You feel really good, and those are the ones we see most often. Or this, I'm their counselor, I'm their caseworker. It's on letterhead. It looks nice and official, right? Gives you warm and fuzzies because you're like, this looks true. The one that people don't like, and I will tell you in the 13 years, I've never seen it, but it could happen, a reliable third party. So this is my child. I can tell you my child has this disability and this animal provides them a service. HUD says that would be acceptable as well. And that gets people stirred up usually. But I'll also tell you, in 13 years, I've never had that as a thing. It's almost always, here's the document I gave them, and they're still saying no. And it's on a prescription card or it's on letterhead. Now, if you think it looks fishy, you also could go, hey, doc, I got this document. Did you fill it out for them?
We're running into trouble with that for HIPAA.
No, you're not asking for, you do not want specifics. All you want to know is, did you complete this? Did you fill this document out for them? You're not violating HIPAA by, did you fill out this document?
So you can't ask about their medical condition that leads to the service animal, but
you don't want to know those things. Like when you're evaluating, why do you get Social Security disability? Why are you on medication? You don't want to know those things, but you can go, doctor, did you really fill out this ESA thing? If it looks fishy, usually we go, if it's on official letterhead, probably the safe answer is just accept it and make sure you hold them accountable just like they had a second tenant in the property. So the animal can't be disturbing the neighbors at midnight, just like you wouldn't let a tenant, howl at the moon. The dog can't be howling at the moon. They're not allowed to chew up your doors, just like somebody's not allowed to punch a hole in your wall. A lot of people hear ESAs, it means, oh, we got no rights, we can't do anything. You still have rights. You treat them just like another tenant that's violating the lease, essentially. If they take care of the animal and there's no problems, then they're just like any other good tenant. Yep. We usually get a lot of them when it comes to ESAs.
Yeah. 2 questions. The first one will be easy. Is there a limit? on how many dogs somebody can have as an emotional support.
See, you say it's easy. That's not really easy.
Should be, because
It should be.
happens all
you know
the
what?
time.
As an investigator, I wish there was a better answer than what I'm about to give you. No. There is no set limit. It depends. There's a lot of factors that HUD says that you have to consider. How big is the property? What is the animals?
But there are other city ordinances that limit how many animals can be in a household.
So there is that. So I don't know what the ordinance is. It's like 7 cats, 5 dogs or
That's
something,
it.
whatever. That's still a ton, right?
So then do they go back to the city? I remember being
They
at
could-
that
they-
annual one, and it's like, go to your local agency and make
So
them.
they could file a complaint or petition city
What do I
council
do
to
as
change
the
that.
landlord? Do I still rent to them, or tell
You-
them they need to get acceptance from
Yeah,
the local ordinance?
You're getting to where I got to give you legal advice, but
No, I know.
But no, you're all right. I know you. Yes, I know. So yeah, I mean, you're out for you is I have to follow the city ordinance. Just like somebody wants to have a farm animal that's not allowed in the city as an ESA, well, the city doesn't allow it. You need to take it to the city. The city allows it, then okay, we'll figure it out.
Well, this is the last thing I'll ask.
No, you're good.
And the reason I ask that is because it leads up to this, and it's probably the first time that I've had that. So we had a couple filling out the application, and they had 4 dogs.
Okay.
2 of them had ESAs when they turned their application in. They were relocating from out of state. Everything was going smoothly, including this.
Well, that's
and then
sounding good.
They verbalized that they were going to get their other 2 dogs ESAs. Because their realtor said, hey, you know what you should do is you should get those dogs ESA paperwork so you don't have to, pay the fees. When they verbalize that to my face, well, how would I respond to that?
Take a deep
It's like-
breath. I wouldn't like hearing that either. Somebody comes in and wants to file a complaint in our office and they say that. I wouldn't be happy hearing that because what you just said is the reason why people have issues with ESAs. There's going to be a game played. People that want to break the rules, they're going to do it, right? So, and it depends if I understood it right. One, they're going to get them ESAs. Again, it does not matter if they got a document saying this dog's an ESA. They need something that says, I need this dog because of my disability. So that's number one. A lot of people, you can go online, answer some questions in some places, and I'll tell you, I did it because I had a landlord go, hey, somebody gave me this. I'm like, this has been years ago. I've never heard of it. Here's the website. Check it out. I answered it one way, every way that, yes, I should be approved. Put in your credit card number, $99.99, and we'll send you this document that says this is an ESA. I answered it all the wrong ways. Made sure everyone should have been, no, you don't need this. $99.99, you're going to get that same document, right? So we started going, hey, we've never seen this, but this online thing, HUD's come out and go, comes out and goes, them saying this dog is certified is, am I on camera doing that? Nikki's going to be making fun of me.
That'll make for a great replay.
Right? So HUD says that doesn't matter. It's, again, about that medical provider, that counselor, that person with that third party with knowledge that they have a disability and they need it. That's what's important. Now there's some state law and federal law right now in Indiana doesn't match up unless state law's changed and I haven't caught up. But there's I think the state law is they have to have an in-state document, I believe. Right? Well, I mean, Indiana was tweaking the law where it says it needs to be documentation from an in-state medical provider. Federal law says, no, that doesn't matter. Because now there are some like therapists online, like we saw one that came from New Jersey. And then it's like, are they really your patient or did they do the $99.99 thing like they did? And those are tough. We don't have good answers for those yet.
So I just wanted to say that it's 7:30.
Oh.
So if you have to leave, feel free to leave. But if Dennis is willing to keep talking, we have the room till 8, I believe. So
I can go to 10.
Oh, well, I mean, I'm not going till 10, so
I'm
just,
off tomorrow.
If you
I'm
need
willing
to,
to say
leave, feel free to sneak out. And thank
There's
you for
just
coming.
there's so much in housing that it's hard to get it all in an hour and a half. And I'm like, I don't really want to cut anything out because it's all so important. Did you have a question? It was just about the internet. Oh, so yeah, those are really tough right now, and we haven't gotten a clear answer. I know I have my own personal beliefs, but unfortunately, my beliefs doesn't make it so.
Okay, so we covered ESA.
Uh huh.
Now let's go to the 2-year certified service dog.
The service dogs. So, service animals, really, really simple. They don't have to have a certification. A person can train their own service animal.
So, I'm sorry. So, service animals are different than emotional support animals.
Yes, they're different because they actually do work.
Okay.
So, seeing eye dog.
Right.
Seizure dog.
Mm-hmm.
There's that difference. We typically say for landlords, don't even bash your brain trying to figure out. It's does the person have a disability and does the dog assist with the disability? But there is a technical difference. But they don't have to pay somebody to train the dog. So they don't have to come and go, my dog went through AAA seeing eye dog school. They can train the dog themselves. So they don't have to provide you with a certificate going, they've gone through this training.
But blanket for both, they can have a document from the doctor.
But they can, I mean, if somebody's blind, do they really need to give you a document saying, I'm blind, I need this dog?
Right.
If it's obvious, you shouldn't be asking for stuff. But if the way that any accommodation thing works is, if it's obvious, they show up in a wheelchair and you know there's 2 steps to get in the door, you shouldn't go, do you have documentation saying you need a ramp to get in your house? No, you're in a wheelchair. That makes sense, right?
Right.
But if there's going, I need an accommodation, and their disability's not obvious, or the need for the accommodation's not obvious, that's when you can go, do you have some documentation showing you need this? So it could be, hey, I need a parking space closer to my door. Well, you're walking, you're not using a cane. I don't understand why you would need this. So, but it could be a heart condition. They can't walk too far before their heart would give out. You don't know that by looking at them. So do you have some documentation that tells me you need this? And again, the doctor's going to go, my client has a health condition and a parking space outside their door will assist them. Cool. Kind of the same thing for the animal. If it's not clear, you can ask.
I have a question about policies for applicants. So over the course of time, markets change, policies can change, become more stringent, based on the applicant pool. What should a landlord do to protect themselves as those policies are changing, so that if there ever was an issue or a complaint that was filed, my understanding is that the Metro line is, we're going to dig through your files the last 10 years and we're going to find one exception. What if that exception was okay back then?
Well, if
how do we know it wasn't
I don't know who told you that we
issue?
do that, but I've been there 13 years, and to go back 10 years, it's going to be more than that scenario. But we would rarely do that, and we'd also look at what was the rule then, what's the rule now. We're not going to hold you accountable for a rule that wasn't enforced at that time.
Okay.
I mean, like fair housing, 1974 was when disability was brought in, right? We're not going to go, in 1973, you denied somebody because they're disabled. That doesn't even count.
I guess more what I'm thinking is, maybe pre-COVID, you were in one sort of policy realm.
So
post-COVID, you're doing things a little bit differently.
Big thing is, if things change, send out the information that, hey, rules are changing. You're putting everybody on notice. Here's the new deal. So don't like keep it secret. Somebody goes, oh man, I think they just threw this on me because they want to get rid of me because I'm, right? Nope. Market values change because housing market's so tight. Hey, everybody, just so you know, because the market values changed, when your lease is up, we're going to be reevaluating the market rate. You're giving them a chance to know that, hey, this is probably going to change. It's not a surprise. I'm assuming it was an example like that.
I'm going more in like the screening process.
Oh. So if you, well, I'd like.
You can't really tell people that
Aren't your, right. If they're already in, you're not really screening them anymore, right?
Right.
So that's just where you would have a document. Here's our old lease. Here's our updated lease. This old lease is no longer being used. That old form is done. And as long as you're consistent with that new lease, that new rule from that point forward, as long as you're consistent with that, that would also be a legitimate non-discriminatory reason. Yeah, this was the rule back then. This tenant lived here back then, so this is why that's in their file. This tenant's only been here years, and we updated our lease agreements on, and if you look at everybody that moved in from this time to this time, you'll see that it's consistent. You're going to be fine. I would be amazed if we found anything that would be a problem as long as you're consistent once you institute it.
We have another question over here.
Okay, if a tenant moves in with no disabilities, a year later, they're all of a sudden in a wheelchair.
Yep.
Do you have to accommodate their disability at that time?
If they make a request, you want to engage in the interactive process. I'm gonna kind of wimp out a little bit. It depends what their accommodation request is. So maybe an example, I can't go up and down stairs anymore because I'm in a wheelchair and you don't have an elevator. I need accommodated. Okay, the accommodation is we have a vacant first floor unit. You can move to that. So in that case, HUD would say you should move them. If you go, hey, we don't have anything right now, but you would be able to move into the first available unit, HUD would say that would be considered reasonable accommodation. When it comes to making accommodations, the thing you don't want to do is go, no, I'm not going to work with you. You just draw the line in the sand and go away. I don't want to do it. HUD would say you're probably going to be in trouble. But if their request is unreasonable, you wouldn't have to accept that request. Example, it's a 10-unit apartment complex with stairs, and they go, hey, you need to put in an elevator now. I only got 10 units. This is the only property I own. I don't make enough money to afford to install an elevator. That's not reasonable. Here's how I can reasonably accommodate you. This person's going to be vacating in the next month. That unit is yours on the first floor. So it's in having that conversation. Yeah, I understand you want an elevator. That'd be awesome and great. But I'm not a multimillionaire. That's not reasonable. So the person doesn't always get the specific accommodation they ask for necessarily. But if what they're asking for is just not reasonable, that's
the reasonable part.
Yeah, that's what you got to think of. Okay, I can't do that because it's not reasonable. I can't afford it. It's an undue hardship. What can we counter offer that will get them what they need, and it's not being a burden?
Isn't it a basic if it's a small adjustment to the property that does not permanently change the structure of the property?
Right. Hey, again, those simple, and usually what we see are more simple ones typically. Hey, there's 5 steps to get in my unit. Can I put in a ramp? Yeah. HUD would go, don't deny that. Yeah. You can ensure it's done professionally in a workmanlike manner. You can't charge them extra fees, but you can have them go put money into an escrow account saying, when you leave, this needs to go away. And if it doesn't, I get to use that money in that escrow account to return it to the condition it was in. If they get it all removed when they leave, they get that escrow money. It's not yours unless, kind of like a security deposit. If somebody leaves the unit in good condition, they get their security deposit back, right? Same thing with that escrow thing when it comes to an accommodation issue.
Okay.
How many years of applications should we be retaining?
Generally, this is actually an interesting question because, man, I saw we're researching a thing that's tied to a harassment issue. Typically, we would do a year in most cases. Sometimes, depending on the particulars of an issue, we may go back 2. So we typically go we like to have 2 years available if we need it. But we were looking at, it was a harassment one, so what is it, patterns and practices? The Department of Justice tends to do fair housing harassment ones, they take it over. They went back 20 years looking at applications. Metro didn't do that. We're like, how did you find 20-year-old applications? They're like, we found an application in 2003 where the person didn't even move forward because as they were applying, I mean, 1, they found this application, 2, found the person that applied, 3, interviewed the person that said, yes, they were harassed 20 years ago. And it was used against the business. It was like, I think it was Ohio. Because I want to say our staff attorney said, I went to school there. I want to say it was somewhere in Ohio. But yeah, so we have never done that. I can't say that we wouldn't. 2 years is usually safe if you're dealing with Metro anyway.
I think if nobody else has any more questions after this one, I think it's probably about a good time to wrap it up. But the question that I had was about, I don't know if I missed it, because I know there's been a lot of Q&A just this last little bit. When we see about residents not being charged pet deposits for their service animals, does that include like the physician and therapist certified ESAs?
So anything that if an animal's tied to their disability, whether it's a service animal like a seeing eye dog or that emotional support animal, none of them can be charged additional fees. You can't charge an extra security deposit because I was guessing that was the next question. No? Okay.
So with that being said, is there a way, because I know that, of course, I'm not a landlord, I'm not a tenant. Is there a reasonable way a landlord can ask for proof of that to know not to charge X fee?
That would be, again, if you go, this is my service animal or this is my emotional support animal, and it's going to be more the ESAs, the emotional support animal, because typically that means they're not blind, which blind is obvious why they need the animal, right? The ESAs are more for that PTSD, anxiety, maybe autism, where it's not quite so obvious. That's where you can go, do you have something from your doctor, your medical provider, your counselor, your caseworker that says you have a need for this animal because of a disability? And so we did kind of cover this, but it's going to be generic. This is my client, this is my patient. They have a medical condition or a disability that this animal assists them with. You get something official like that, that's all you need to go, yep, we need to approve it. Again, I like to remind you though, but they still have to clean up after them. They're not allowed to destroy your property. They're not allowed to be a threat to neighbors. They have to obey leash laws. We have a guy that keeps wanting to come to us and file a complaint because his property keeps saying that you have to have your dog on a leash. No, I don't. It's my service animal. There's leash laws. Yes, you have to keep it on a leash. You have to have it under control. Could there be some weird scenario where that could be different? Potentially, but I'd have to be shown it because other than that, you still have to follow all the laws. We had a guy going, I don't have to prove that they're vaccinated. No, the law says you have to vaccinate your animal to have an animal. And if they're going, regardless of it being a pet or an ESA, you got to prove that you have the vaccination records. You got to do this.
How about requiring that they be neutered or spayed? Is that an option?
Never had that question before.
Where's that illegal?
I would go
lawyer.
I'm trying to work it through my head. I would say talk to an attorney, but I mean, yeah, I would say talk to an attorney, but I'm like, that doesn't have anything to do with the person's disability, so I could see the argument why you could do it, but I'm not an attorney and I'm not telling you to do that. And if you have a question, just come see me.
And it's Metro. You are more than welcome to email
Contact
them,
us
call them.
anytime. I was also meant to bring our Equity for All study. I grabbed 2 stacks of the annual report because they look really similar. But we did a study throughout the city, interviewed 800 plus citizens about employment, housing concerns that they had. really interesting, a lot of really good facts that's going to help us lead directions on training and doing things. It's on our website. You're more than welcome to log into Fort Wayne Metro and check it out. Sorry I didn't bring it. Sorry I didn't get through the whole thing either, but I knew I wouldn't.
And if you have any questions on the flyer that you got, there is an email for Becca at the VLP. You can email those questions to her, and we will work our best to get those questions answered. So at the 4th series, we can fill in all those holes. Thank you, everybody. See you at the 3rd one next month.
Okay.
Production facilities provided by Access Fort Wayne. Learn more under the Explore tab at acpl.info.